Today's visitor is someone that we're really excited to have, and we're going to be commencing a series of episodes regarding patent law, intellectual property, trademark, copyright, and various other aspects related to that part of business law. And in the future, we'll be doing live feeds with answering your questions with Steve Parmelee here today from Fitch Even from Chicago. And Steve is a double E and a jurisprudence doctor.
JD, so yes.
Yes, Doctorate of Jurisprudence.
Right, I don't often get asked that, but.
So, welcome, Steve.
Well, thank you. Glad to be here.
This is just going to be really fun and fantastic and such a resource, and you're being very, very generous and really appreciative. And I know of Steve from our association with a group here, a tech group here, but when I was in a startup weekend with a group and we came second, the only one to get to MVP in 56 hours, and the girls that came up with the concepts, you helped them enormously in guiding them, and I'm very cognizant of how generous you are with your help there, and so you're the perfect person to help lead entrepreneurs. And so what's a little bit of your background first, so that we know that there's a person behind the lawyer?
Well, as you said, electrical engineer. I went straight from, and that degree was earned in 1975, so aging myself a little bit.
Why did you like electrical engineering?
Actually, in high school, math and science, I had good grades generally. Math and science were kind of what was more interesting. But on the other hand, my real interest was music. And if you think back in time, if your memory runs that far back, that was when we started to see things like the Moog synthesizer, guitar effect pedals. Electricity in various ways was a part of the music scene. The recording industry was changing and so forth. So I really didn't know what I wanted to be. Actually, I did know what I did not want to be. I did not want to be a lawyer. But that's because my dad was a lawyer. He was in workman's compensation law, and he was doing 3 to 4 trials a week.
Oh,
so it was a very grueling kind of practice, and that was my whole, with blinders, understanding of what law was about. So yeah, I didn't want to do that. If I went into electrical engineering, that might open this pathway into the music world.
Which is interesting, because if you look at a brain map, music and math are neighbors.
People tell me that, and I, sure, they're both cool, so I can see why one would follow the other.
So where did you grow up?
Actually, Central California. I was born in the San Francisco area.
Lovely.
Lived as far south as Salinas, which is like 100 miles south, which is known for lettuce. And then my high school years and early college, that was in San Jose, as it was struggling and beginning to become Silicon Valley.
As we're doing the same thing here.
Yeah, when I was a kid there, I mean, we had plum orchards behind us in San Jose.
How gorgeous.
Yeah, now it's an asphalt something or other.
Yeah.
But yeah.
So was there some of that energy and electricity
around? Not that was getting to me.
Not getting to you.
What was getting to me was it was becoming more crowded and polluted. Smog was very, very, very bad. Oh. So I went to college, electrical engineering. I went to the Midwest and really liked the Midwest. I never went back to California. No offense to California, but it's not the same California it was anyway. But right. Yeah, I liked Four Seasons. I liked the Midwest vibe and so forth. So anyway, I was in electrical engineering, and it sort of dawned on me that engineering is cool, but I'm not quite sure this is necessarily it either. And I don't remember the moment when I learned about or decided that patent law sounded interesting.
Was it fairly close after you finished graduating?
No, before.
Oh, okay.
I took my LSAT, which is the SAT, if you will, for law school. And so I went straight from engineering into law school. And once I had the first year of law school under my belt, this was Omaha, Nebraska. There were 2 patent law firms in town, both small. And I went to both of them saying, you should hire me as a clerk, and then I can learn about this stuff. And they were both like, we have no idea why that would be of any value. But I also had 7 years of industrial drawing experience in school. And
CAD drawer?
This is before CAD. This was Bristleboard and India ink.
Oh, okay. Oh, right.
And so one of the law firms bid on that. They were like, well, yeah, we could use you as our illustrator. So I started doing patent drawings. And that gave me the opportunity then to beg to let me please write a patent application. And they finally got tired of me and let me do that. And that just opened the door. I became a patent agent, passing the patent office's agent exam while I was in law school.
Is that uncommon?
Not particularly common.
Right.
I mean, there are people who become patent agents and then later become patent attorneys.
So what is a patent agent compared to a patent attorney?
Patent office is an administrative agency that is the guys who examine patent applications and give patents. To be licensed to represent other people before them, you have to take and pass their exam. To take and pass their exam, you have to have certain prerequisites. The key one, besides being of good moral character, you have to have some kind of technical background. You can demonstrate that with a technical degree, which electrical engineering did, or you can show practical experience.
Which you had both?
No, not really. No, that would be like, say, working in a chemist's lab, as an assistant.
Okay, so
substantively involved for 10 years.
So your patent drawing that you're drawing.
Yeah, that didn't count for it all. Okay. But I didn't need it. The electrical engineering, the agent's exam is miserable. The pass rate year after year is like about 1 out of 3, and that's like with half the people taking it for the second time or more. It's just an awful exam. You get through it. If you are not an attorney, you're a patent agent, and you get your license and you can represent people before the patent office. If you are an attorney, you're a patent attorney. So that's the only difference between patent attorney and patent agent. So I was a patent agent. I graduated law school. I took a bar exam. I became a lawyer. And then the patent office sent me a new piece of paper saying, now you're a patent attorney, although my registration number stayed the same. So, and then I practiced from law school. I went up to Minnesota. I worked in a 50 lawyer law firm that was corporate business practice. I was the second patent attorney they had. It was a terrible experience. They didn't know how to cross-sell patent intellectual property work to their clientele.
Oh.
So it was basically left to us to go find somebody, and when you're just a two-man shop and you're competing against considerably larger firms, it was a tough go. So I eventually left there before I got kicked out, basically. I went back to the firm that I had worked with in Omaha, basically as a place to land. The Midwest was in a depression at that point in time. Not a depression, I'm sorry, a recession. But things were kind of tough. And that kind of was stagnating as well. And about that point, we decided, right, I say we, my wife and I, thought it's time to try something different. And so I looked at in-house practice, and I ended up looking at it and interviewing at a number of places. And I ended up going with Motorola in Chicago. Joined them in '84.
And what stage of their life cycle were they?
Well, this was amazing times. The very first cellular stuff was happening, being demonstrated in '84, '85. And I got to work with what was called the land mobile section, which think of them as the first responder radios. So everything from Car 54, Where Are You, if you're old enough to know that reference, to police radio, firefighter radio, that first responder type radio systems. But those were the guys that just kept inventing. Their inventions are what led to cellular, as far as I'm concerned. Their technology is what was leveraged to become cellular.
And this is for everyone that's out there. This is pre-cell phone towers.
Well, yeah, cell phones were not yet there.
Yeah.
Motorola, the first cellular telephone call, it was basically, what was it, Motorola and AT&T? I forget who the main competitor was, racing to get that first radio that worked in the system. And the first call was from a Motorola engineer to the counterpart engineer saying, guess what I'm doing?
Oh my God.
An amazing time there. Paging happened, came and went.
Mm-hmm.
just, semiconductor type technologies were blossoming, and although Motorola had large semiconductor facilities and engineers in other places, the land mobile people weren't satisfied. They needed solutions. They just came up with them themselves.
It sounded like there was all this confluence of technology that you
Was driving.
More so than there is today.
Yeah, well, certainly with Motorola, because they were parsed
They're more
and split.
specialized now, and it sounds like back then they had everything in the pot.
Right, and it was, a lot of design freedom to go where Motorola, arguing in hindsight, it wasn't the greatest idea. They put the Iridium system into space, which was to allow you to make basically a cellular-like phone call anywhere on the planet. What happened from the idea to the implementation is that cell phone calls got pretty ubiquitous and cheap. So there were like 50,000 people on the planet who actually needed the service. And if you looked at the cost of building the system, it was like, well, that didn't work out as well as we might have hoped. It's still a business today. They've just replaced the Iridium constellation, or are in the process of it, because technology's gotten to the point where it is more cost effective. We still have people that need to talk on an oil platform in the middle of the ocean or whatever.
The Iridium lasted well then.
Pardon me?
The Iridium lasted well.
Well, it did after going through bankruptcy, and the cost of the cost of running the business was reduced because they shed a lot of the debt in a bankruptcy. But
the Iridium, just the technology itself per se, just as an aside, was
robust. Well, actually, and from the patenting standpoint, that was really interesting stuff, because in a cellular system, your users are moving with respect to the towers, so you have to hand off for that reason, which is kind of a key part of what's going on. In Iridium, the stations are moving relative to the users. So you still have that movement and handoff, but it's totally the opposite side of things.
It's Landsat, basically.
So it was, just bottom line again, every day was something new. It was just an intoxicating time.
And how long were you there for?
17 years.
So you were it was just blow and go the whole time?
Yeah. In fact, more so. During the time I was there, Motorola entered and for years stayed in the top 10 recipients of U.S. patents. We were just cranking it out.
And how many did you say that you had in the portfolio?
About the time a lot of that was sold to Google, I think there was like 25,000-ish U.S. patents.
And the value of those patents alone?
I think alone, there can be arguments. Yes. As I recall, I've seen estimates from $9 to $17 billion, something like that.
Not shoddy.
Not
So they're
bad.
definitely an asset, and we were talking before about there's certainly an instrument of value.
Yeah, Motorola gets credit or blame in many circles for having. IBM maybe gets ground zero, patient zero credit for having introduced aggressive licensing to the world, knocking on your door saying you owe me money in a big way. Motorola was a good student on the, and in many parts of the world even sort of opened the door to that.
So what's the difference that you're talking about IBM and then Motorola being a good student? So would you explain that a little bit?
IBM, forever is like one of the largest, if not the largest, recipient of patents. They just have a gazillion of them. The quality of them probably ranges all over the map, but the fact is there's a gazillion of them. And at least for a while, they seem to have a strategy of eventually, if you worked with something that had a computer somehow, some way, and modern radios and cell phones, they certainly do that, they'd knock on your door. You owe us money, and you're going to pay us money, and you have access into our portfolio. You don't have to worry about us. I'm making this very simple. And if you pushed back, saying, "I don't think so. What do you mean? What patents am I infringing?" They'll give you 7 or 15 or 50, and you look at them, and it costs money to look at them and study them and think it through. And you find one that's kind of sketchy, maybe we do. The others is like, I don't think so, or we don't have to, we can get away from these. And you give them that answer. Oh, so then they give you 250. and you get the idea.
They're going to outspend you,
This,
out-lawyer you.
yeah, this, it's not so much out lawyering necessarily. It's just, you know, it's that massive a pile of things. And so a lot of people would actually, you know, okay, I'll maybe negotiate the amount. And so, you know, we, to my knowledge, Motorola never did that, but we had a lot of patents, and we became very keen on, in certain markets, we wouldn't license. This is our market, and a patent has the right to exclude. We're excluding. So, you know, this is our market. In many other places, the door opened, though, and it was quite the mindset change for some people that we're going to let people use our patents, but they're going to pay us for it. A lot of people who were skeptical of that became believers when they saw the amount of money that could come in from that. And it became a legitimate, you know, profit center. You know,
And
Motorola
enable those other companies to...
Well, people learn from that. I mean, just the way Motorola learned from somebody else, maybe. Again, I'm painting with a very broad brush here. And
it just sounds like a really interesting time. So why did you leave Motorola?
I survived maybe 5 or 6 rounds of head cuts. You know, and Motorola was at its height, I don't know, 120,000 employees. The inside patent department, I think at our peak we had 120 patent attorneys and agents around the world. We were in offices around the world as well as in the U.S. So we didn't ship out very much. We did it ourselves, including a lot of litigation. We were a separate law department from the law department. We were bigger than the law department. We even reported differently. We both reported to the CEO through different channels, which for a large company was probably the only company I know of that had that. And that had historical roots, and there was some personalities involved, and there was the success of the licensing program, kind of like it ain't broken, don't fix it. And that eventually changed.
Okay.
And the lot of, you know, it was called a merger. Maybe it was an unfriendly takeover. Although bigger, the patent department reported to the law department. And Motorola's lawyers were good lawyers.
But you're more technical. It's almost like sort of like a morph between
it's
engineering and law.
It's even different than that. On the patent side, with licensing in mind, we were kind of more the junkyard dogs.
Oh, really?
You know, snap and growl and let us off the leash, and we'll go bite and, you know, achieve the business end we're trying to achieve. The traditional role of a lawyer in a company is to minimize risk. You know, don't market it that way. Don't say that. Don't do these behaviors. You know, put these posters up that tell people how to behave. It's minimizing risk. And when you do a contract, you know, we're protecting our position as best we can. So what we were doing, for God's sakes, we sued people. There's almost nothing riskier than to go sue somebody. A lot of things can come back when you do that. You know, you start a war. Even if you win this battle, are they going to come back some other day? So you have the mindset is totally different. And, you know, that alone was a huge paradigm shift for both sides. And then with the headcount cuts that were happening, with Motorola selling pieces of itself, with research, basic research becoming less and less peopled, budgeted, planned, and manned, there was less emphasis and need. And consultants, by the way, you know, consulting is a great gig. I've decided what consulting is. Tell me what you do. I'm going to look around and see what other people do, and I'm going to tell you they're doing something different. You should do something different. And now here's my bill. And we had consultants come in. And I think I mentioned our reporting structure and our size was odd in the world because we did the work ourselves. And at that time, what consultants could easily was to point to everybody else, saying, look, they have these smaller departments. Mm-hmm. How do they do it? They outsource the work to other lawyers. Wow, does that work? yeah, in tougher times, you don't have to fire anybody. You know, you don't staff for your bubbles and all those kinds of. I'm not saying that's wrong, but
It is a business reality.
You know, it's that was the norm. So we stuck out like a sore thumb in so many ways. So you know, it was almost, we knew what the consultants were going to say, right? They were going to end up with that,
So they got
a different solution.
consultants in to say that they need more consultants.
Well, I don't know. I mean, yeah, the conspiracy theorists said that we hired people to tell us what we wanted them to tell us.
Yeah.
But you know, even putting that aside, that's where, if you looked at the world and you say the rest of the world is what you're benchmarking on, you're odd. You know, are you odd because you are the best, you're the outlier, or are you odd because you're trailing the herd and they're all going in a different direction?
Oh yeah, no, we don't like to trail the herd.
So like I said, I survived many rounds of head cuts. In hindsight, I wasn't enjoying the job as much because it had changed. My last couple of years were not as full of the piss and vinegar that made it so cool.
Now, did you go to? Was that where you went to Japan and other places? Was that?
Well, no. You're thinking Singapore? I was put into. Actually, it was around the time this was starting to happen. I went to Singapore for 2 years, which was great. But when I came back, I came back in '99. I left in 2001, so that kind of tells you that this is when this, you know, things were changing a lot.
You know, Ericsson. I remember in Dallas. You know, we had all the.
Yeah, Motorola was down there, by the way, in Fort Worth.
And you know, they were, you know, growing up, and then they just crashed. Awfully.
Oh, Ericsson?
Yeah, Ericsson, and there was Motorola, Ericsson. It was just
Nokia came in a little later.
All of the, you know, just there was a boom and bust.
We thought the reason all those other guys were there is because we were there, and they started hiring our engineers. I don't know.
Well, there was a lot of foreigners there, and we had a lot of foreign friends who'd come in from Norway and the UK and Germany, and then it just, the bottom fell out about the time that you, sounds like it was about the same time that you got back.
You know, like I say, you know, it was, in hindsight, you know, where send a letter to yourself. Yeah, I maybe should have left around 99 or 2000. Instead, I waited to be booted out. You know, as our headcount kept reducing, and you know, letting me go saved a lot of salaries for, you know, we could keep 2 or 3 other people. When I left, I joined the Fitch Even firm, and the first thing I did almost was write Motorola patent applications. I was contacted by people at Motorola, and they were like, "Can you write patent applications for us?" And I was like, "I love doing that." So yeah, so for a number of years.
So you became the consultant.
Well, no, the outside service provider. But yeah, I mean, so, you know, for a while that was a great thing. So my opportunity to work with what I thought were some of the best engineers in the world, and certainly conversant with the patent side. So they were not only good engineers, but they got what we did. And so they were just a dream to work with. And I still understood the business well enough to be able to contribute from that standpoint as well. So, you know, yeah, that went on for a few years.
I bet the firm was really happy with that. So when you're going through all this, your love of music is something that today you put out music, you're creating all the time and playing all the time.
Yeah, that goes back to, I mean, all I'm doing with music, which is write songs and record songs, is something I've been doing since high school, you know, since 1968. So I see it as just a natural continuum. It's like somebody who says, I like to paint, or I like to knit, or I like to whatever kind of a creative outlet they have.
Did it get you through the harder, you know, with those
Oh,
uncertain times?
Oh yeah, absolutely.
How important was it for you to have that music?
I think, you know, there's moments where it's probably, when I'm in that space, kind of nothing else exists. You're just in that.
In the flow.
Yeah, and you know, other people can fairly listen to what I do and go, oh my. But for me, you know, I'm feeling a high from that of sorts. You know, there's a creativity being expressed. It's like, yeah, that came out nice to me.
So when you're in this flow state, and everything's all cut off, when you get back to work,
oh, you're in a better place.
You're in a better place.
Oh yeah, over the years, for whatever reason, you end up supposedly somebody looking to you for wisdom. One of the few contributions I've ever made, I think, is, you often hear, if you get a job doing something you like, you'll never go to work a day in your life.
Right.
You'll like doing that. And that's true. And I feed on what I do for a living. I love that interaction with inventors and working a patent application, which is its own creative event. You start with this blank piece of paper, and on it you create this statement of what the invention is. So
because
there's creativity in there.
Because it's how it's crafted depends whether it's going to be successful.
Yeah, it's not filling in a form day after day. It's creating this written statement of
So
something.
you've got this beautiful interaction of your legal and your technical background.
It is very much that. Once in a while in a social setting, people will say, "What do you do?" And I don't, for whatever reason, feel like having the conversation. Oh, you're a patent attorney. My uncle, and then I hear these stories. I'll just say I'm a professional writer because I specialize in nonfiction mostly, and that's true enough. But
do you enjoy that? Employing the technical side still?
Absolutely.
Yeah.
No. There's no question about it. When I started in this business, microprocessors were huge. I mean, desktop computers didn't exist yet. And so I've grown up with, in my profession, through the whole ranges of microprocessors to, what happened in communications, just all of that, seeing some of it from the inside out. And that's been an enormously cool experience.
And then we're going to be looking to the future with AI. And we'll touch on that later, a little bit later in the conversation about AI and patent law and what that may impinge upon that from the patents, the administration side and permitting side, but also with creating patentable items or technologies. But what fascinated you first about patent law? What was it that really was interesting?
I don't know. It was that merger. It was definitely a fact that technology carried into it. And I suspect it had something to do with those drawings, and because you're part of creating those to express a story, and then the written word side of it. I mean, I always did like to write. I mean, that's part of even writing a song. The lyric side of it is there's prose going on there as well. And, so that wasn't a negative, that was a plus. But it's no more firm than that. I really don't have a good statement except that as I did it, I don't think it took very long for me to discover that working with inventors and hearing, in any setting, whether it's in a big company or medium or individuals, hearing what they did and why they did it and all that is just more often than not a joy in and of itself. I as an engineer, okay, here's a seed. Put the seed in, you nurture it, you grow it, get the light on it, get the right food to it, get that flower so it's there. So you got all that work for that flower. I'm like the bee that gets to go flower to flower.
Yeah.
I come in, I check it out. This is awesome. Grab some pollen, go to the next flower. And, so instead of the guy growing the flower, I'm the bee, and that's maybe the best answer I can give you. That's the...
I'm curious about whether or not you see that there's, with your music and creation and inventions, that there's some, talking about cross-pollination, that there is one reflects the other when you're creating music and playing music, that there's some
certainly
sort
nothing
of,
conscious there.
Yeah.
In fact, people that hear my music would be horrified if they're clients probably to think that there's any cross-pollination
I've heard
at all.
his music, and if you like, we'll put a link to your music site. And the name of is it a one-man band?
It changes over it's called the Baha Brigade. which is an odd enough name. And that's kind of from day one, it's been a variety of people. It's whoever happens to wander in. So sometimes it's a one-man band, and other times there's many people involved.
So he
It
has
just morphs.
this album called Christmas Fruitcake.
Which is not a Baha Brigade album. That
Oh, it
was a
isn't.
solo album.
That's a
yes.
solo album, and it's actually really good. And so you play all the different various...
All the instruments that
all
are
the
on
instruments.
that. Yeah.
That's really good. So if you like, we'll put a link to it on our...
That's not hard for people to find. That one is actually on Spotify and wherever else. I marvel at where it keeps wandering to next. I don't have any control over it, appears. It
and
just
he called
goes
it Christmas
places.
Fruitcake because...
Well, it took me 12 years to do the album. And so when you think of what's the one Christmas gift that takes a lot of effort and heart, and then when people get it, they really don't want it, that's fruitcake. So that's my Christmas offering. Yeah.
It's really good. Patent law is actually more interesting than people might think it is. And one of the reasons why we have you here and getting to know the person behind the lawyer is to diffuse some misconceptions about lawyers and then also about patent law, because some people are terribly afraid of it and then other people are overly fond of it, and you've got the whole spectrum. And you were talking before about people who've actually gone bankrupt about it. But I thought one thing that seemed to be interesting about patent law was this. It's been around a long time in various forms. Like 500 BC in Greece, they had, I think, the first forms of patent law for recipes, that you could get the income off a recipe for a year. And then in England, I think in the 1300s, 1400s, they started issuing patents to the king. The king started issuing patents.
They were monopolies. You have the patent on soap, monopolies. You get to make soap and nobody else makes soap.
But when we talked about, when we look into, as it started to modify and there was started to be time limits, it seemed to coincide with, especially with Venice and Florence in the 1400s, it seemed to coincide with as it created industries and profits. It was the same coincidence to the Renaissance, and then in England later on with Queen Anne coming in, then you have the start of the Industrial Revolution happening at the same time. We've got these waves of laws coming into effect and people starting to use patents. And that's just my observation. I'm not saying it wouldn't have happened with it, but it seemed to be a confluence.
There's certainly a belief, and I think it's generally a correct view. At the edges, you'll always find the exceptions, that done properly, an intellectual property system drives innovation rather than inhibits it. And the rough idea is if we protect the rights of innovators, then they can receive the fruits of their innovation and hence be inspired to innovate more, and other people will be inspired to innovate themselves.
And people can understand that from the music industry, where people get paid for the songs that they create.
You pay me enough, I'll write some more songs.
Yeah, because you want, we've actually interviewed young lads here with starving artists who want to help that collaborative effort.
You're talking about the history of kind of generally, if I can make a rough kind of summary of things. First of all, we have a number of intellectual property laws. You got patents and copyrights and trademarks, and there's some others. There's the right of publicity. There's things called mask works. You might ask, so why do we have, if you want to own land, there's kind of like one idea. You do or you don't, and then you've got leases and other things. But so why so many intellectual property rights? What's up with that? And a simple answer is because not one of them is perfect. If it actually perfectly protected, you might arguably not need any others. It would just do the trick. And the intellectual property laws we have, in fact, can overlap. They're not discrete little silos of what they do. You can have a given product that literally is protected by copyright, trademark, utility patents, and design patents, all on one effort. So how's come they're imperfect? Didn't we learn something in all these years you're talking about? And the answer is, what was learned is First of all, if you don't have any intellectual property laws, innovation is stifled and it suffers. And it does because people keep things a secret. And you end up with father handing down to son, mother to daughter, whatever, the tiny guild that knows how to do this particular thing, and nobody knows about it.
And they can't market it and as much as they can.
Right. So you can't stand on the shoulders of giants and see further because everybody's, keeping the giant locked in a room. This metaphor fell apart quickly. So no intellectual property laws gets you no innovation. Conversely, perfect intellectual property laws, like the King's patent
With a monopoly.
for soap,
Yeah.
that's granted on who you are, not on the quality of your product, also stifles innovation. Because nobody else has any motivation to make soap, because they can't. And the person who's got the soap right has no incentive to spend money to innovate, to make it better. Why should they?
Yeah, so you've got this free market. It actually helps reasonable patents help create a free market.
So there you go. No intellectual property laws and perfect intellectual property laws lead you to the same bad place. So we know we need intellectual property laws. We know they can't be perfect. And now that you've got imperfect laws, they're going to change over time because you're going to have to move them because technology changes, markets change, people's expectations change, opportunities and all that. That moves, so the law once in a while is lucky enough to get ahead of it, more often is dragged kicking and screaming to catch up to where the world's gone. But yeah, intellectual property laws change over time.
So what about trolls? Because a lot of people are concerned about going and getting a patent because they're afraid that somehow they're going to come across a troll. And that may reflect that they don't understand patent law very well. But my reading is that there's now some efforts to change those abilities of trolls. So if you'd like to just
talk about that a little bit.
Talk about trolls, because they really do scare the living daylights out of people.
Well, first of all, we'll try to define a term or two. Yes. There is no strict definition of a troll.
Right.
The word comes from the idea of the terrible little man hiding under the bridge. They didn't build the bridge. They don't own the bridge. But to cross the bridge, they demand a fee. So it's like I'm paying for something that apparently I really shouldn't have to pay for.
And adding no value.
Add no value, but they're terrible and ugly and scary, and that's why I'm paying.
Yes. Because there's one attorney who's he's reputedly gets $26 million a year just as a byproduct of being a good lawyer for trolls.
Well, so let's come back to our definitions again, all right? So the word troll gets bandied about, and when people are trying to be more polite and a little more meaningful, they'll say NPE, non-practicing entity. What they're getting at is the thing that gets very offensive to people is somebody who doesn't really make anything, they don't manufacture anything, but they maybe buy some patents and they have however it comes by, they have the wherewithal to put them in the face of people saying, this patent covers what you do and you need to pay me. You pay me the toll. Maybe the most offensive version of that is when they do almost no research except to discover you make some product that uses a computer. I'm going to guess the computer does something on the internet, and I've got a patent that arguably does something with the internet. So I send out 1,000 letters and I say, you infringe the patent, here's the patent. And if you give me $20,000, $50,000, I'll give you a paid up license. Now that's an amount of money. A typical patent trial, I think the Bar Association says that's a $1 or $2 million legal cost. So somebody comes to your door and says $25,000 or $50,000, you go to your lawyer to investigate it, and you discover I might spend that much figuring out that I don't owe this guy anything.
So it affects the small guys and the mid-sized guys. But when does this behavior I'm trying to think of the legal term of enforcing someone to pay something. Extortion.
Well, extortion, I mean, if you think of maybe a pseudo-legal definition, is you're forcing someone to give you value when you have no right to receive it.
Well, isn't that what they're doing? Especially if they have no legitimate claim.
Well, if there's no legitimate claim, then yes. And that's where the worst behavior comes in, when you see they don't know me, they don't know my business, and they've put something in front of me and they're waiving a cost that I can pay, that in context, they carefully picked a price that it's going to cost me more to fight it. So It's like, I hate this, but it's easier to pay them and just have it go away. That's the kind of behavior that most rankles a lot of people. At the other extreme, you think about what a non-practicing entity might be. A university doesn't make anything, but they can have a research group,
which did produce that.
Which produces patents.
Yes.
With legitimate effort and so forth. And then that school looks and they go, we got these patents. If people are using them, if people are using that technology and we invented it and we have a legal right to it, and we do the research and we can show you're using this invention,
right,
and they go knock on their door, I would argue that's just fine. That's the system.
Because they created the value of that patent.
And now you get everything in between, kind of what most people would argue is pretty darn bad behavior. And at the other end, behavior we want to encourage.
Right.
Really.
Because they're like musicians that have had their songs.
Whatever. I mean, they're contributing to the world in good ways. And now, on this spectrum, you find things happening. And so when people rail against, trolls, sometimes they use words that would seem to capture that whole spectrum, which I think that's unfortunate, because they're going too far. And then when people, I acknowledge that, now how do we try to, clearly it's easy when they're just out here extorting. It's just that obvious. But now as you move this way, where does the behavior is something as a society we want to try to control and so forth. And there are things that have been done that are trying to have an impact on that, and probably are having an impact. At the same time, if you're aiming at this, but you're affecting this, is that good? And none of these things are perfect. So to the extent people apply controls, you probably see them trying to.
It becomes on a case-by-case basis. So how much does common law, the old British common law, come in, where it was what the rational, reasonable common man would think? Does it ever come into that area at all?
Well, of course, we're reasonable and rational folks, and so there would never be an analysis not that way. But I can't think of anything that's
because a common, rational, reasonable man would totally understand the university versus the other one.
Well, the fact is, a patent is simply an asset, and as an asset, it can be bought and sold. It can be partitioned. It
sounds like a mineral right.
It can be leased if you want.
Yeah.
So I can be the guy who makes a claim on a piece of land and I never did any digging on it. Mm-hmm. But I made the claim, and then somebody else came along and discovered there is gold here. They need my permission to mine it. Well, that's how the world works. I own that land.
Right.
And if I have the mineral rights, then you got to pay me.
Right.
Am I a troll? Don't think so, even though I'm not a miner.
But you had bought, right.
All right.
Yes.
But so to get a patent, you go through a pretty costly and difficult process to get that patent. That patent doesn't give you the right to do anything except stop other people from doing something. That's all it is a negative grant. I can sell that to somebody. So the fact that I sell it to somebody, the right is what it is. If they legitimately apply it against somebody, meaning there's genuinely somebody out there doing what the patent covers, that...
Not as a nuisance because you're a 10-ton gorilla and you can just get the money from the...
Maybe even if, now you get into, people do legal things and they're jerks. It doesn't mean they're not a jerk, but it doesn't mean what they're doing is illegal either.
So my understanding was a lot of the time that the trolls will bring these cases against people where there's no really.
And there's a lot less of that these days.
Okay.
And for a variety of reasons. It's gotten easier to more cheaply challenge patents, and there are courts, I think a lot of courts are a little more willing to, in some instances, sanction a bad actor, which means not only you lose, but yeah, you pay their fees. Good. You pay their attorney's fees. You do this, you do that. And you do that a couple times, and it's a fairly chilling effect on that business model.
Yeah. So to me, it seems that if you have a product or a goods and service that could be patentable, and you go and get your patent through a law firm, that process will actually help you identify and discover if there are any potential conflicts out there.
It's not designed in, it's not baked, it's not a goal, but it is something that can happen on the side.
Right, because otherwise if you're just going off willy-nilly.
There's folks, for example, that will say, I've got this patent, I've had it for 10 years, what can I do with it? And they go maybe talk to an attorney or a troll by any other name. One of the things they might do is you just do a database search looking for other patents that cite this patent as prior art. Meaning there's something about what you did that's relevant in somebody's examiner's mind to what now has been done. So you look and you discover there's 10 or 100, and you read these patents and you discover 3 or 1 that is your idea, but now it's improved. That's what they were trying to do. Well, my patent's still alive. It looks like if you're doing what you're doing, you probably infringe on what I'm doing. I got a patent on the pencil.
Right.
And you are trying to patent putting an eraser on a pencil. It's got a pencil in it.
But isn't that the first thing? One of the things that a little bit of law that I studied was you had a pencil that had a patent and an eraser that had a patent. But when it was put together,
that's another patent.
It's a totally different patent.
Yeah, and that's you get to a big industry like semiconductor or the communications industries and so forth. There's cross-licensing everywhere because you invent something new, but you're building on what came before. Yes. The odds are really good. You infringe somebody else, getting to where you are. And conversely, everybody keeps building on each other, so you end up in this big mesh. And sometimes it takes a while for the industry to figure itself out. When a new industry comes along and sort of grows quickly, you sometimes see a problem where everybody discovers they've got a patent, and they're thinking, I want 5%, of the, because that's like an aggressive but not so bad royalty. Problem is, for anybody to put a product out, there's like 20 or 200 patents that apply. So if everybody got 5%, it doesn't work. And sometimes it takes a while for the patent owners to discover that kind of their value's diluted, even if it's like you can't do it without mine. Mm-hmm. Yeah, but you can't do it without all these others.
Like an oil and gas mineral. You can get like 0.00025% of.
And so sometimes industries will like create patent pools. Sometimes they'll just cross-license in a very general way. Whatever I got, whatever you got, it's free both ways. Or I think I got twice as much as you, so you give me 2%. Or, right. I'm really being flippant here with these numbers.
I'm really curious here about, and this would be a totally another conversation another time, is about open source. So this is sort of like, it brings up all these different questions.
Interesting thing about open source, just to touch on it.
Yes.
Open source would not work without intellectual property rights. Because open source basically says, if you use my open source stuff for whatever you want, whatever the license, whatever it says, and then you don't play the game and let other people leverage what you did,
right,
then I'm going to use my intellectual property rights to crush you, to make you stop. So once you've bitten the apple, you have to you can't escape. You've been transformed. And so you have to keep playing the game. that leverage wouldn't exist without intellectual property rights in the first place.
That's really interesting.
On what's been
Yeah,
open
'cause
source.
I was always curious about how that survived and thrived.
Oh, it's
Linux, for example.
you know, I'll use a couple names with all due respect, and it's because it's so easy to find out what the real names are. So Cisco bought Linux, not Linux,
No.
Linksys,
Linksys, yeah.
which is like home access points and so forth and so on, and they paid $500 million. Turns out that Linksys used open source stuff and did not reciprocate by letting the world understand what was in the Linksys box. I'm being very general about describing this. And the folks behind that, sued. And at the end of the day, Cisco, having bought Linksys, had to pay a bunch of money for having basically kind of buy themselves back into good graces, and then had to open the kimono. And, some people argued, to a good extent, all Cisco bought was the name Linksys, because all that was proprietary was suddenly revealed and opened and available. At that point, every lawyer on the planet involved in this suddenly added to their due diligence checklist for a merger or acquisition. Do you use open source? And if you do, we have a lot more questions about whose and what are the terms, are you compliant, and all like that.
And that's a good lesson for people, especially younger kids who are out there using Linux and other open source platforms, is that if they go off and create something using that they can't go off and...
You can't, trying to turn proprietary, something that the people really get upset about this, say infected with open source code, again, it's like you bite the poison apple, you are now changed and different.
So is that if someone did that, hypothetically, would that be picked up by the patent office attorneys?
Patent office could care less.
Okay, that's interesting.
They don't care. But there's companies out there like Black Duck is a good example. Their whole business model, at least a large part of it, is give us the code you want us to look at, and we will compare it against all the open source stuff that we're aware of. And we will give you a report, what open source is in here and what licenses. Is it Apache 2? Is it GPL 2? What is it?
Now, are they using AI to evaluate whether
I don't think they are. I think it's just a straight, easy comparison. Okay. Just string by string, you're just looking and can make the comparison. And then, then you have this report. Say you're buying a company. You don't even have to take anybody's word for it. You just run their code through Black Duck, and you get this report, and you can go, okay, no open source. Or you have open source, and it's this one. Okay, the license for that says this. Are you compliant? And are we okay with that?
Right.
Or the worst case kind of stuff is there's like 3 different open source things in here, and the licenses are conflicting. You actually have a product here that is illegal in the world of open source because the licenses aren't all the same, and they literally can conflict in ways that are you can't reconcile them. You just have to tear the code back out again.
That's fascinating. I'm curious about, so what is, from your perspective, what is some of the, like a story or two of when you had someone's had a patent, a small business has had a patent, and it was a difference to them being, and again, as we were talking about in our conversation offline, was you can have a patent, which is an asset, but it's like a tool, and you were saying that, is it the right tool? Is it the, but that doesn't guarantee that it's going to be successful, because if they're going to put too much money into the patent process, is it, that's not guaranteeing that they're going to put work into it and marketing and the correct materials or anything else like that. So a product or goods and service is not necessarily guaranteed by a patent, but has there been some stories that you've come across where having that patent really made a difference?
Actually, you said it really well, but for, looking for an example or two. And one thing that kind of bites my tongue is attorney-client privilege can play into this. And
yes.
Personal stories, I'm a little loath to go too deep
right.
into anything. And then I'm thinking of, what about stories that are more apocryphal within our industry.
Let's go with those.
And for what it's worth, there is a patent attorney out there who, you know what a table saw is,
Mm-hmm.
and you know that they're terrifying machines.
Mm-hmm.
They, the spinning blade of doom. Mm-hmm. And people lose digits and parts of their digits every day with table saws. And he saw that as a problem. And I don't know whether his patent practice wasn't flourishing and he had time or what, but he decided to do something about it. And so he invented what's called the Saw Stop. It's a real product. And it's a system that detects when flesh is encountering the blade, and it stops the blade instantly. So the worst you get is kind of like this little cut. When you see one of these demonstrated, they always do a hot dog instead. But there's just a little nick in the hot dog when they just jam it into the blade. It destroys the blade mechanism, and it's like a $70 cartridge. You have to, so then you scold the person that did this, but you get back to work, and insurance rates go down for the people using these and so forth. So being a patent attorney, he did everything right. And he patented this thing really well. So saw stop machines are out there. And
he's benefiting from the...
Well, now this gets us kind of to where you were. Saw Stop is a well-recognized brand. I think it's had a slow growth. For the technology that it is, I mean, you'd think like, why wouldn't everybody? But it's a definite premium on the machine. Mm-hmm. So it's a lot more expensive. And if you're a guy starting out in your framing business or whatever, and you look at the two, it's like, oh, geez. And you go into a Lowe's and a Home Depot and all that, you're more likely to see a non-saw stop machine. Because with the patents he's got, which not surprisingly were done well, so nobody's out there with anything similar, until the patents expire, Saw Stop as a brand is it for this feature. So it's not that it's not succeeding, but you look and you see all these other competing machines out there, which clearly sales are happening that aren't Saw Stop sales. And it's an interesting question, and one that you can't answer for not having done the test. But if he had instead, maybe put it on the market to prove to all the naysayers, my gosh, it works, and people are willing to pay some premium for that. And he then licensed it to everybody else at a rate that was attractive. Mm-hmm. So Saw Stop, as a quality brand may still be higher than everybody else, but everybody else is also offering this. So no matter, at that point, some point, it's like airbags in a car. Right. It's like, well, there's industry regulation, but maybe even then you get a state or the feds or somebody who goes, that's got to be there now. It's just the standard. Would he have made more money with a thought-through licensing program as versus being utterly exclusive? And I don't...
If he hit every tier.
And right, let the other people turn their marketing loose on it.
Right. And as you said before, competition
can validate a market, can create a market.
Right.
I give you another kind of interesting example for what it's worth. Polaroid was a big business in instant cameras. I mean, that they were it for instant film, and instant film was a big deal because everything was film, and this way you could get your picture right away. And Kodak said, we're going to get in that business. And they got into that business. And there was, a battle royale in the courts. And Polaroid wasn't going to license. It's exclusion. We're going to use that part of our patent. And they won. They kicked Kodak out of the instant film market. And Kodak looked around and at that point in time said, what's this digital stuff? And the world... a disruptive technology came along and made, Polaroid's still out there, but it's a really, really niche.
And I'm wondering if the patents expired because now it's trendy to have these
little... Well, the original ones certainly are.
Because you've got these now little Polaroid type.
Right, they're kind of a faddish thing. Young people are like, hey, look at this. Get this instant picture. So, again, if Polaroid had licensed Kodak, obviously digital was coming and going to disrupt all that. But instead of spending the large amount of money they spent stopping Kodak, instead had kept that money and gotten more money, accepted a reduction in market share, but maybe Kodak would grow the market. Maybe. So you don't know without
exactly. And
history playing out a different way.
Patents actually play a huge part when you have them into your business decisions. And
well, and then that ultimately does, ultimately patents doing what they should do. They should support your business plan. Sometimes I think they get led into positions of greed, or greed's not necessarily the right word.
Or
something where they become more confrontational in a way that maybe isn't as ultimately beneficial.
Yeah, if they could just think that now I've got the patent, I can actually expand the marketplace. How can I benefit, and how can the marketplace benefit from this patent being utilized, as you call it, an asset?
Other patent attorneys and patent business people watching this, half of them are pulling their hair out, screaming and yelling that no.
We want to hear from them.
The slant I'm giving, and admittedly, I'm just raising this as a concern, because just from what I've seen over the years, there are times when exclusion plays well, but there are many times when I think I've seen it. You just are wondering, was that the right way to play this?
Because patents, like any tool or any asset, it's more than you can ask really big questions, or you can ask very small questions about its utilization or deploying it as an asset. And as you've said before, you could have a truck, but the truck may not be good. You might need a delivery van instead. So asking the questions about where you are in that niche and that business, and how you're going to grow it, and how can you monetize it, how can you protect yourself but still capitalize on it.
And by the way, patents are a strategic asset, which means, in part, you can answer the question today, and tomorrow the answer may be different. And to not re-challenge yourself once in a while.
But you should be doing that with all your assets anyway.
Exactly. But again, with patents, sometimes
people forget about them.
They buy them by the gallon and they put them on a shelf.
Oh, and that's something that we're going to talk about later. So we have to wrap up here, but we're going to be talking about, so what areas are we going to be covering in our future episodes is patents, the intellectual property, trademark, copyright.
Sure. And open source if you want.
Open source. But anything else, and then like the patents, we'll be reviewing this over time, and then if people have questions coming in, and we would love to do a live streaming in the future where we have people bringing in questions, which your response will not be legal advice. It will be
never.
It is just we're just talking about generally just a guiding.
Yeah, it's becoming better armed to have a good conversation with your intellectual property professional, or amongst your own community as well.
And also in your business decisions as well. Because I think some of the questions you have to ask in going through this process is key to really having a strong understanding of your own business plan.
Yeah, if you don't have that, you need to go back and get one before you go any further.
Exactly. And so this is a good exercise to go through, whether or not you're going to go to patent.
I mean, it's part of it. It isn't it, and if it is it, there's concerns about that. Maybe you're a troll.
Is this a troll-free zone? But on that note, we'll wrap up right at this moment. But this is going to be really exciting. This is going to be an amazing resource for so many people, and it's also going to evolve, just like patent law, intellectual property law. It may be kicking and screaming as it changes, but we hope to keep up and keep it going as a current resource for everybody. And thank you so much for being here today, Steve.
My pleasure.